Good morning. Welcome to the University of Montana. My name is Pippa Browdy, and I'm a professor at the law school here. I teach courses on tax law and policy.
I'm Anthony Johnstone, and I teach courses in constitutional law and legislation.
It is our privilege to welcome you to the Supreme Court's hearing of the case Espinosa versus the Montana Department of Revenue.
This case is about a state tax law that supports scholarships for private schools, parents who want to use those scholarships for religious education, and whether the Constitution prohibits or requires the state to allow that use of tax-supported scholarships. Let me note that I've consulted with the state on this case, but the views I express this morning are my own.
We want to preview the arguments this morning for you by introducing the Constitution, the courts, and this case. Anthony, let's begin with the Montana Constitution.
Well, Pippa, in 1972, 100 ordinary Americans in Montana created an extraordinary document, the Montana Constitution. After debate and by popular vote, the people of Montana adopted our Constitution by the narrowest of margins. It replaced our 1889 Constitution, which was hastily ratified in order for us to gain statehood. One of our most important constitutional rights is to see our government at work.
That's what we get to do this morning.
Right, Pippa. The three branches of government put our Constitution to work, and officials in each of them are sworn to support it. The legislature, our state senators and representatives, and the people through the initiative power write the laws. The executive, the governor, the attorney general, the board of regents, and other state officials, and our local governments enforce the laws, and the judiciary, our Montana Supreme Court, and local lower courts apply the laws by deciding cases. Pippa, tell us more about the courts.
In Montana, we have two levels of courts, both federal and state. We also have 7 tribal court systems in each of our 7 tribal governments. The federal courts are led by the Supreme Court of the United States, which is in Washington, D.C. The federal courts generally hear questions arising under the U.S. Constitution and federal laws. Although state courts sometimes consider federal law, in fact, the U.S. Constitution requires state courts to do so, as in the case you'll hear today. Most laws are state laws, however, and most courts are state courts. State laws and state courts have by far the greater impact on our lives. Anthony, tell us what the state courts do in Montana.
Well, statewide, our Montana courts hear 1,000 cases a day, hundreds of thousand cases a year. First, trial judges and juries hear those cases and decide them. Sometimes lawyers present facts, evidence, through witnesses and documents, and judges and juries decide the cases based on those facts. Sometimes a judge decides there are no factual arguments worth arguing over and grants what we call summary judgment based on the law alone. That's what happened in this case. In a few hundred of those cases, one side or the other doesn't agree with the decision and appeals the case to the Montana Supreme Court. At the Supreme Court, as you'll see here today, there are no witnesses testifying to facts, only lawyers for each side arguing the law. Most of these cases pose the question whether one side or the other, one of the parties, has followed or violated the law.
But a few cases question an official's action, whether an official's action itself is legal or constitutional under the Montana or U.S. Constitution. The case today asks such questions about the state's actions. Anthony, what does it mean for a government to act unconstitutionally?
Well, Pippa, when we, the people, formed our state government, we gave the government certain powers and duties, like the power to make laws and collect taxes and the duty to run a public education system. But we also retained certain rights, like the freedom of religion, the right to observe government, or the right to privacy. The Constitution is a deal we, the people, made with our state government. We made the same deal with our federal government through the U.S. Constitution. If the state government itself violates the higher law of the state or federal constitutions, then the law is invalid. It broke the deal.
One way, the main way we the people hold our government to the constitutional deal is through elections. When we think the legislature, executive, or courts aren't doing their constitutional duties or respecting our constitutional rights, we can vote them, including our state judges, out of office.
Another way is by going to court to challenge the laws the legislature passes or actions an executive official takes. Sometimes you go to court as a defendant, such as when you're accused of a crime based on what you think is an unconstitutional search of your home. Sometimes you go as a plaintiff, such as when the legislature passes a law that you think violates your right to privacy, or when you think a state official has wrongly denied you a public benefit based on an incorrect reading of the law. That brings us to the issues that will be considered here today. Recall, the parents here wish to send their children to private schools, but they seek financial aid to help them pay for it. The legislature wants to help them do that through the tax system. Now, Pippa, can you tell us some of the ways the tax system supports education?
Certainly. To understand the tax issues in this case, it's important to understand how the income tax works and how the government raises revenue. With an income tax, a tax rate is imposed on income earned. For example, if the tax rate is 20% and there is earned income of $100, the tax would be 20% of $100, or $20. After tax, the individual who earns the $100 would have $80 left. See, there's both a rate of taxation, 20%, and a base for what gets taxed of earned income, in this case, $100. So the total tax is $20.
So that leaves the taxpayer with $80 and the state with $20 of tax revenue, right?
Right. The state can use that $20 to support education in several ways. It could, for example, simply combine it with other tax revenues to run a free public school system. It could also make what we call a direct expenditure, where it collects the taxpayer dollars and pays them out for specified purposes. For example, it could offer parents vouchers or scholarships to pay tuition at private schools or public universities. Or the state could make what is called a tax expenditure. You may hear that word today. Instead of collecting all of the tax and distributing it, the state could give a tax break to parents or students to reduce the effective cost of tuition.
Okay, but tell me more about how tax expenditures work.
Sure. If the government normally would collect $20 of tax from an individual, but gives a tax break worth $5, it's as if the government collected the full $20 and gave back $5 to the taxpayer. The $5 of lost revenue is the tax expenditure, and the taxpayer would be left with $85 in their pocket.
I see. Now, in Montana, we require a balanced state budget in our Constitution. So the lost revenue from a tax expenditure must be made up either by raising other people's taxes or reducing the total level of government services available, right?
That's right.
Pippa, what are the different types of tax expenditures that we may hear the parties discuss today?
Great question. First, there's tax exemption. A tax exemption or an exemption means that an organization or entity is not subject to taxation at all. For example, charities, including most private schools, both religious and secular, are not subject to tax. They are tax exempt.
So using our above example, if the school had income of $100, it would pay no tax and keep all $100 to use at the school.
That's right. It really helps private schools to be tax exempt. But it doesn't directly help the parents who are trying to pay for their kids to attend.
Okay, so what if I wanted to more directly support those kids?
Another way to support students would be to give a deduction for tuition paid. A deduction is a reduction in the tax base itself. So using my example of $100, you could have a deduction of $10. That means that the income earned subject to tax would be $90.
So a person could pay tuition or donate to a school scholarship fund and deduct that value from their income.
Exactly. The deduction reduces the income tax base. So in the example of a $10 deduction, reducing the base to $90, the $90 is then subject to the 20% tax rate, which means that the total tax, I did the math, is $18. A $10 deduction, you see, only results in a $2 of tax savings. So the individual would have $82 after tax.
$2? After all that trouble, that's not very much money.
Well, there are also tax credits, which are much more valuable to a taxpayer. Tax credits are usually dollar-for-dollar offsets of the total tax due. So using my above example of $100 of earned income, a person with a $10 credit would normally pay $20. But with the tax credit of $10 offsetting dollar for dollar the tax due, the individual would pay just $10 of tax. Obviously, this is the most advantageous for the taxpayer because after tax, the individual has $90.
So a person could donate to the school scholarship fund or pay tuition, and the full value of the donation or payment is credited against their tax? That sounds like a pretty good deal. Why can't I just make a donation to the students directly, though?
Sure, you can donate directly to the student, but you won't get a deduction for it. The tax laws do not allow the donation to go to a particular individual. So here, the legislature created a tax credit for donors who donate to what is called a school scholarship organization, or SSO. The tax credit the legislature enacted is a dollar-for-dollar offset for donors who make up to $150 in donations to such a scholarship organization. And the legislature limited the total amount available for tax credits to $3 million.
That sounds great. But there may be a wrinkle. I think most private schools in Montana are religiously affiliated, and the Montana Constitution prohibits aid to religious schools. So when the legislature proposed the tax credit, people raised concerns about funding religious education. The legislature said the purpose of the student scholarship organizations is to provide parental and student choice in education with private contributions through tax replacement programs. But it also said that the tax credit for taxpayer donations under this law must be administered in compliance with the Montana Constitution's restriction on aid to religious schools. And it told the Department of Revenue to adopt rules to implement the law.
Well, what does the Montana Constitution say about that?
Well, the key provision that will be discussed in this case is Article 10, Section 6 of the Montana Constitution. It says in part, aid prohibited to sectarian, meaning religious, schools. It says the legislature shall not make any direct or indirect appropriation or payment from any public fund or monies for any sectarian purpose or to aid any school controlled in whole or in part by any church. You're going to hear those words a lot today. So the Department of Revenue, which administers the tax credit, issued a rule declaring religious schools ineligible for the student scholarships supported by the tax credit. That rule, denying scholarships to religious schools, led to this case. So Pippa, what's happened in the case up to now?
In this case, the plaintiffs are parents of children who want to send their kids to religious schools in Montana. We'll call them the parents. We'll refer to the defendant, the Montana Department of Revenue, as the department.
They'll sit there. Parents will sit there.
The parents sued in state court in Flathead County. In short, they argued the Montana legislature provided tax credits to support scholarships for their children to attend religious schools. And the Montana Constitution permits those tax credits. And finally, the Montana and the U.S. Constitutions prohibit the department from denying those tax credits to religious schools.
Yes, and the trial judge in Flathead County agreed. Without hearing testimony, she granted the parents summary judgment on their legal claims. And she ordered the department to provide tax credits to support scholarships for religious education. The department then appealed to the Montana Supreme Court. Pippa, what are the department's arguments?
Well, they're the mirror image of the parents' arguments. The department argues the Montana legislature excluded religious schools from receiving those tax credit-supported scholarships because the Montana Constitution prohibits such aid to religious education, and that the Montana and U.S. Constitutions permit the state to exclude religious schools in this way. Let's go through how these arguments will play out today. We'll start with what the Montana legislature meant when it passed the tax credit law.
Okay. So the parents argue the legislature intended religious schools to be eligible for tax credit-supported scholarships. After all, they argue, most private schools in Montana are religious schools. And after the legislative session was over, the legislators actually took a poll saying that's what they intended. The department argues the legislature excluded religious schools from the tax credits. The legislature, it argues, understood most of the beneficiaries would be religious schools otherwise and amended the law specifically instructing the department to follow the Constitution's prohibition on aid to religious education.
That brings us to the second issue. Anthony, does the Montana Constitution prohibit aid to religious education through the tax credit?
Well, we'll see. But the department argues that this particular tax credit represents the kind of indirect appropriation or payment of public funds that the framers of the 1972 Constitution were worried about. The parents argue the money at issue is a private donation, not an appropriation of public funds, and other states with similar constitutional provisions do not prohibit such tax credits.
There's a third issue of religious freedom. Even if the state law or state constitution prohibits tax credits for religious education, right?
Right. I'll get out my U.S. Constitution now. The parents argue the freedom of religion in the First Amendment of the federal Constitution and related provisions in the Montana Constitution as well prohibits the department from discriminating against religious schools. The department argues to the contrary that the freedom of religion justifies the separation of state funds from religious education, which is historically a special concern for both the U.S. and state constitutions.
So those are the arguments of the parties. There are also several amicus curiae in this case. What role do they play?
Amicus curiae, Pippa, is Latin for friends of the court. They are groups that bring different perspectives of the case for the court to consider. Many national groups supporting school choice and religious freedom have joined the parents' side. The United States government, through the U.S. Department of Justice, is also siding with the parents in this case. On the department side is the ACLU and other civil liberty groups, as well as the Montana Quality Education Coalition, a group that supports public education in Montana.
Anthony, please tell me what will happen after the argument.
Well, after hearing the arguments, the justices will meet in conference to discuss the case, vote on which side had the better arguments, and assign opinion writing duties. If the justices are unanimous, there will be one opinion written by one justice for the whole court. If the justices disagree on the outcome, whichever outcome that is supported by at least 4 justices will prevail. And one or more justices will write separate opinions, either concurring or agreeing with the result, but for different reasons, or dissenting or disagreeing with the result.
And what if the losing party wants to appeal the case further?
Well, if either side disagrees with the court on a question of Montana law, they're out of luck. The state Supreme Court has the last word. But because this case involves questions under the federal Constitution's First Amendment, the losing side may petition the Supreme Court of the United States, which has the last word on the federal Constitution. Although the Supreme Court only hears about 5% of cases lawyers bring to it, so in most cases the state Supreme Court is the last word even on matters of federal law.
With all that background, let's get started. Because the department lost in the court below, it is the appellant in this case and will argue first and last. It is represented by attorney Dan White. The parents are the appellee in this case. They will argue second. They're represented by attorney Richard Comer.
The Montana Quality Education Coalition, remember one of the amicus curiae, will also argue immediately after the department. They are represented by Jonathan McDonald.
This is an official judicial proceeding, so please remain silent and seated during the arguments. Turn off all of your mobile devices and remove your hat.
The Deputy Clerk of the Supreme Court, Rex Rank, will begin the proceedings. Chief Justice McGrath will introduce the court.
We wish to thank the Montana Supreme Court for sharing these important proceedings with us here today at the University of Montana.
And thanks to all of you on this fine spring Montana morning for joining us today.
Enjoy.
All right, give your attention. The Honorable Justices of the Montana Supreme Court.
Good morning. Nice of all of you to join us. We hope that we've chosen a case that will pique your interest. I know the lawyers are interested, but I'm glad to see so many of you here. My name is Mike McGrath. I am the Chief Justice of the Montana Supreme Court, and I'd like to introduce the other members of the court who are here today that you may or may not be familiar with. On the south end here is Justice Jim Rice. He's our senior member on the court, and we have Justice Jim Shea. To my immediate left is Justice Lori McKinnon. Next to me is our newest member, Justice Ingrid Gustafson, and Justice Dirk Sandifer. Justice Baker is ill today and will be participating in the case and following the arguments online. Counsel ready to proceed?
Yes, sir.
Mr. White.
Mr. Chief Justice, honorable justices of the court, my name is Dan White, W-H-Y-T-E. I'm the Chief Legal Counsel for the Montana Department of Revenue, and I'm here on behalf of the department and the state in this matter as the appellants. May it please the court. The issue before this court today is clear. Whether Rule 1 is necessary to ensure that the tax credit scholarship program is constitutional under Article 10, Section 6 of the Montana Constitution. The legislature passed this program in 2015, and as part of that legislative history, late in the session, there were concerns about whether the law as written would be unconstitutional because it may implicate public funds to religious schools. Late in the session, the legislature added a provision that gave instructions to the implementing agency, that is the Department of Revenue, instructions to ensure that this new act was construed and applied to Article 10, Section 6 to make sure that it was constitutional. That is what the department has done through its Rule 1. Now let me describe for you what this case is not about. There have been many, many issues raised about religious rights in this case. Agreed, we have religious schools and religious institutions that are implicated. These are public funds that go to private schools. However, we are not interfering with anyone's right to attend private religious schools. In fact, the claimants, the plaintiffs here, the families, currently attend Stillwater Christian School. That's in their complaint. They've indicated that they are going to continue to attend there, so we're not interfering with that. We are not interfering with anyone's right to donate to this program. You or I or anyone here can donate at least $150 or more to the student scholarship organizations. We are not interfering with anyone's right to claim a tax credit. I can, if I am a parent of a religious school and I want to donate money, I can claim the tax credit. If there's somebody who is a parent of a secular school student, they can claim the tax credit. So we're not preventing anyone from getting that. There are donations to other programs that are available. ACE Scholarships gives over 500 scholarships to private religious school students annually. We're not interfering with that at all, and this program doesn't deal with it. And then there are also other tax benefits available to the schools and to parents that are already in place in Montana law, and we're not interfering with that.
Counsel, excuse me, the briefing asserts that although the statute and the rule are not directed at religious schools, that as a practical matter, it disproportionately or almost exclusively impacts religious schools. Is that accurate?
Justice Sandifer, without the implementation of Rule 1, that is correct. Of those schools that are signed up with the Student Scholarship Organization, and the money has to go through a Student Scholarship Organization, 11 of 12 of those schools are religious schools. And the scholarship organization also affiliates itself with 23 other Catholic schools. So all told, 34 of the 35 schools that are available to receive scholarships through this fund are religious.
So what relevance, counsel, is that in light of the decision in Mueller and Zellman that the inquiry is not who the majority of the beneficiaries are? I mean, the Supreme Court has dispelled any notion that the actual effect of being only religious schools is not to be considered.
Justice McKinnon, that's an interesting point. There's also the case of Nyquist, where 85% of the students were religious school students. So in that case, the Supreme Court did strike that one down. The interesting thing in cases such as Mueller is that there was a truer, across-the-board, neutral program for a deduction of family and student expenses, and it wasn't just either in purpose or ultimate effect like here, where it goes to religious schools. Additionally, in Zellman, it depends on where you put the denominator, because while in Zellman they said 96% at one point, Justice O'Connor in her concurring opinion said, if you add magnate schools to that, which are public, if you add community schools to that, it drops it down into the teens. So suddenly it's a different metric where there aren't nearly as many religious schools that are implicated. In this case, without the rule, we have over 90%, and that's why it's different than those Supreme Court cases.
Counsel, if you look at those, the statute 1530-3111, in isolation, that may be true, but if you look at it in combination with 1530-3110, I mean, it allows for the identical tax credit for any donations to public schools, correct?
Justice Shea, these are two separate programs. There is the one that is specifically for public schools, and then there's the one that is for private schools. And while it looks as if they mirror each other, they are actually two separate programs. They're two different funds that monies go into. One is a public fund, and then it goes to regions in the state. This one is a student scholarship organization. It goes into that funding, and then it gets diverted to the private schools. So they just work totally differently under the law.
So if they did an amendment that just combined and gave the same provisions but essentially combined 3110 and 3111, would that address the concern that you had essentially, because they operate exactly the same. I mean, there's the $3 million aggregate limit, there's the $150 cap. If you combine those two statutes on paper and not just in practice, would that address the concern?
Respectfully, Justice Shea, I don't think that would address the concern, because there's no question that public funds can go to public schools. That's what the public side of this program is. We have instead public funds that are being indirectly diverted from the public fisc into a scholarship organization, then to these private religious schools without Rule 1. So it doesn't fix the problem because of the allowance of public funds to public schools, but the prohibition under Article 10, Section 6. And that's a good segue to saying that. There's been questions here as to what the public funds are. And the families have said, this is my money that I'm giving to this donation, so it never reaches the public funds. An important point here is that as we earn income in the state of Montana, that's our money. The donation, actually, that you pay to to the organizations is your money. What we're talking about in this case, though, is a tax liability that each of us owes on the income that we earn. The Poor versus Boardman 1935 case for the Supreme Court, which is 45 Pacific 2nd 307, Poorman versus State Board of Equalization, said that tax liability is the property of the state, not the property of the taxpayer. Now, the state then has its expenditure program that says, here's our public budget. We are going to allow for tax deductions and credits and exemptions, and we'll subtract that from the ending fund budget. But it's part of that budgetary program. And all of that tax liability that you and I owe is part of that public budget, that public fisc, until such time as you file your return and the state says, okay, we're going to give you that money back. So in this case, it is definitely public funds or monies. And that's part of this indirect route. The legislature, through the legislative history, said, well, we know we can't give it directly to these schools. So what we're going to do instead is create the scholarship organization, and we'll funnel it through that. That is exactly what what Delegate Blaylock during the Montana Constitutional Convention said. We don't want this kind of indirect payment to go to religious education.
Counsel, so you have to distinguish this case from the Supreme Court cases, Arizona versus Wynn, which clearly says the tax credits are not funds for services to establish a religion. So where does Montana's constitutional language regarding indirect appropriations, where does that fit into the First Amendment establishment and religion clauses, and how, first, but also, is it in conflict?
Justice McKenna, you asked a whole lot of things there, so let me do my best to answer all of them. The first place that you were going were the Wynn cases and that line of cases. Montana is very unique in its Article 10 section, in its no aid clause. That's the term that's used throughout the country. It is more specific than cases like Wynn and many of the others that have been mentioned, Gaddy in Florida or in Georgia, and then others, because many of those say no direct funds may come out of the Treasury to be appropriated, and similar things like that. Montana is very unique in that it's not just a question of appropriations or direct payments. It says that specifically shall not make any direct or indirect appropriation or payment from any public funds or money. So we've got an indirect that's different than many states, and we've got public funds or monies that's different from other states for any sectarian purpose or aid to church or schools. So that for sectarian purpose is also very unique. It doesn't just say to schools, it doesn't say to one place, it can say for any sectarian purpose. And it was the intent of the delegates that it both protect the public funds not being siphoned out towards private schools, but there was a whole number of delegates who represented religious organizations, including a very well-respected Helena Reverend, who said, we don't want that public money, and here's why. Because the minute that we get public money, we are of concern that the state is going to get involved. There's always strings that are attached to that. So when they put this together in 1972 and said, we want a very strict constitutional provision, they both agreed, we don't want that money to go to religious schools for different reasons, both for public and for private reasons. But both religious organizations and the public were protected as part of that, and that's what makes it completely different. It also is different if I get to your First Amendment concerns, because the U.S. Supreme Court has recognized that states can have a more prohibitive no aid provision than at the federal level. Locke versus Davey, that you've heard a lot about in the briefing, is precisely one of those cases where Washington State had a scholarship program to private and public colleges, but said the one thing you can't do is allow it for a student who is doing devotional studies in religion.
But Locke was direct funding. It wasn't a tax credit.
But the use of it is the important point of Locke. Two things are important about Locke. One is the point that I was making, that states can have a more restrictive no aid provision than the federal government does. So in those terms, it meets any of the First Amendment concerns. And secondly, while what you say is correct, that Locke also went to the question of use. It went to where are these funds going? And in this case, they're being taken out of the public fisc, sent through a scholarship organization, and without Rule 1, they're going to be channeled to, as applied, they're going to be channeled to strictly religious schools. That's a direct violation of Article 10, Section 6.
So what about Section 1530.23.26, and you cite that in your brief, allows for a tax credit up to 10% of the aggregate that can go to colleges or universities, endowments or foundations, and that includes religious colleges or universities, correct?
It does, Your Honor.
And it's a tax credit.
Yes.
So if I were to give $10,000 to a foundation for Carroll College, that would be, I would get a tax credit of $1,000.
40% on that.
I thought it was 10%, but I mean, in any event.
Yes, a percentage of it.
A percentage. So, but if I gave $10,000 to a foundation that benefited a Catholic high school, I would be limited to $150, correct?
If you're doing it under this program that we're talking about here.
Yes, exactly.
Yes.
So I guess my question is, and also under 2326, there's no aggregate cap of $3 million in a given year. So how is 2326, which would allow a tax credit for donations in Montana to a Catholic college, constitutional, and this isn't, when for practical purposes, this statute seems to be more restrictive than 2326 is?
Well, you kind of hit the nail on the head with your last statement. It is more restrictive in terms of where it goes. So I'm turning that around a little bit on you, Judge Shea. The endowment credit that you're talking about, qualified endowment credit as it's known, is one that's been in place for 20 years. It has never been challenged. It's not challenged under this case. So I just want to make that clear. And this court has not, we're given the opportunity to consider other taxes that weren't challenged but are similar to the one that is being challenged. The Montanans for the Coal Trust is a prime example of that. The court has said we're not going to address those because they're not before us. So that's one. Two, the endowment credit is a very broad-based credit. If you look at all of the organizations that can take advantage of it, it's definitely intended and as applied. It's for all public colleges. It's for various charities that are not related to any religious organizations. And it also does pull in some religious schools. Because of the broad nature of that, it's completely different than this one is. And you brought up an interesting point with the $3 million. This credit itself is so unique to Montana law. It's different in so many ways. Until 2015, we didn't have anything called a student scholarship organization. We didn't have a tax replacement program. We didn't have qualified education providers. So suddenly we have this new program that's allowing a one-to-one tax credit, which is again different than the endowment credit. This is $150 donation, $150 credit, so it's a one-to-one. And it was intended by the legislature to use actual dollars, whereas other credits and deductions are in the expenditure process during the legislature. This one said, we, the legislature, are going to set aside $3 million that can't go anywhere else this year, a total of $6 million for the biennium. We're going to set that aside just for this program. No other law, including the endowment credit, have done that. So this one, whereas the endowment credit is a broad-based, widely accepted program that hasn't been challenged, this one is very restrictive. And the end result is that 90+% is going to go to religious schools.
So what if they were to do a fiscal note instead of saying the aggregate amount of tax credits allowed is $3 million? I mean, that's what they basically do with 2326, is they do a fiscal note estimating what the impact of those tax credits would be in toto, including whether those be donations to foundations that benefit religious schools or universities or public universities or what have you. So, I mean, and I saw in your briefs, there's this talk about setting this $3 million aside. I read Section 5A1 as basically just putting a cap on how much would be allowed in aggregate in a given year to these tax credits. I mean, is there, I guess I'm looking for the nuts and bolts of it. Is there actually where they're taking $3 million and putting it in this drawer and saying, we're going to draw out of that? Or, I mean, it seems to me to be 6 of one, half dozen of the other.
Judge Shea, there is the cap, but there's the mechanics of we're going to put a cap on it so that it doesn't grow too quickly. They were saying we don't want no more than $3 million in there. And if it reaches that cap, the next year it's going to be 10% added onto that. That's the cap piece. That's the mechanics. As far as the budgeting side, they look at what the endowment credit would have cost last biennium in order to determine an estimate of what it's going to cost this biennium. This is different because they said, here's $3 million. It's not going to go to public schools. It's not going to go to anything else. But we're going to set it aside in House Bill 2, which is the budget bill. And we're going to make sure that there is enough money to fund this if it reaches that cap. And that's just different than they've done for any other tax credit.
So, I'm sorry.
Okay, so now I'm lost on that $3 million. I thought the $3 million was an aggregate cap for the amount of tax credit that could be given. Are you suggesting that $3 million is an application in some fashion of Treasury funds?
Yes, I'm suggesting.
How does that work?
Okay. And I might not be explaining myself very well. I'm suggesting that during the legislative process, if you look in the fiscal note and if you look at the legislative hearings, they say we're going to set aside $3 million. It's important to remember that this bill went through both the Senate Finance Committee and the House Appropriations Committee. It never met the Tax Committee on the way. And so it was all about the money. And they said we're going to have a $3 million fund, and we're going to make sure that the money is available to this program. And they don't do that. And I won't.
How is that $3 million to be made available to the program? That's what because you have the money coming in from the contribution that supplies the money that goes out to the to the school. I saw it as an aggregate cap for the amount of credits. Is there actually money that's going to be distributed in some fashion from the Treasury?
There is actual money in the amount of $3 million in the public budget that's anticipated to be used as people apply for the tax credits. So that $3 million that is set aside, that's the best way that I can put it. It's in the state's general fund budget, but it's got its own little sideboards. And it's ready to be used when people apply for the tax credit of $150 as it counts up.
So how does, as a practical matter, how is that different in practical terms from just a fiscal note that says we anticipate that there will be $3 million worth of tax credits going?
It's different for this reason. This program, it goes to the uniqueness of this program, Judge Shea, and it goes to the fact that these are actual public funds. It raises the level of importance on the money piece of it. And I want to be clear that these tax credits are expenditures that come out of the public fund, but this adds just a whole nother level to say we have a $3 million pot that we're going to draw from to send through the scholarship organization.
But it's not a $3 million pot so much as it's a $3 million limit. I mean, in other words, if one person donates to this scholarship fund, the state is out $150. They're not out $3 million because they're only giving the $150 tax credit.
They are giving it $150 at a time. So, but it's funds that are available in the budget.
So if there's only a total of $2 million in 1 year, that fund makes up the extra $1 million?
I'm not sure I understand this.
In terms of credits.
If there are $2 million in credits, then the other $1 million gets put back into the general fund at the ending fund balance at the end of the year.
Oh. All right. Well, if there's $4 million in contributions, I mean, this is a very important distinction from tax credits handled in other cases, and that's why I think it's important to understand where that money's coming from, because it draws directly from our own precedent that, you know, establishes a distinction, and that it's coming from the Treasury. It's an application of funds, and I think it was State versus Dixon and Nicholson versus Cooney both use that language. And I guess I want to see how what you're saying, how that money actually is coming out of the public treasury.
And I'm saying that it's part of the tax liability that each of us has when we earn income. It's in the public fisc until such time as the legislature says we're going to subtract these subsidies, these tax subsidies that we get, and then give those back to the people. So I'm making that connection that it's part of the public budget that turns into indirect funds that go to this student scholarship organization.
Well, then what about in terms of not even tax credits, but tax deductions? I understand, you know, we're talking about a percentage rather than dollar for dollar, but by that definition, if you donate to your church, directly to, not even to a school or anything, you make a donation to your church, you can claim that as a tax deduction, which is lowering your tax liability. So by your rationale, that is money that was in the public fund, because initially my tax liability was higher until I claimed these tax deductions for donations to my church. And that, then I'm essentially, so by that rationale, that money is then going from the state public funds to fund a church.
Again, Judge Shea, those types of deductions are a much broader based itemization of your deductions that you can get as part of the tax structure. The end result of this is that it goes as applied, it goes to the religious schools without Rule 1. So it's the combination of events that get you there, whereas those kinds of deductions that you're talking about are much more broad-based and not in question here. It's this whole program that starts in the public fund, goes through the SSOs as an indirect payment that would go to the religious schools that ties it directly to Article 10, Section 6.
So you say that, but it's the broad base that makes them different than the tax deduction situation. Not all of the deductions that or charitable contributions people make are to charitable or to religious organizations. Is that what you mean by the broad base?
Yes, that's correct.
In this instance, is there a distinction between a deduction and a credit? What we're talking about here is a credit in terms of your tax liability.
Mr. Chief Justice, in the end, they're both tax subsidies that are provided by the state.
Counsel, let me ask you a question about Article 10, Section 6,
Yes.
Sub 1. This provision is directed to governments. It's a prohibition on government action. We might call it state action generally. And it prohibits governments from making an appropriation or a payment from public funds for any sectarian purpose or to aid any church organization. So it's a limitation upon governments doing something. Now, in the program before us, Senate Bill 410, which is the state action here, it's the program, there's nothing in it that directs or requires or mandates any aid to be given for any sectarian purpose or to any church organization. It is written neutrally. And in fact, we could say that there's nothing under it that would require anybody to give to a religious organization. In fact, it's possible under its language that every single person that participates could choose to support a non-religious school because it is written that way on its terms. And that's as far as the state action goes here. There's not any state action here that mandates any aid for a sectarian purpose. It's when private individuals choose to participate and make private choices that religious institutions are brought into the formula. So how does Article 10, Section 6, which is a directive toward governments, be used here to prohibit private choices?
Justice Rice, as late in the session, the legislature wanted to ensure that this was constitutional because the question was raised whether this was going to go to private religious schools. And so they put in the proviso that said the Department of Revenue shall implement this according to Article 10, Section 6. That would have no other meaning than to say, make sure you protect that constitutional provision. That constitutional provision says you can't send any indirect payments to the schools. And once that siphoning off goes through the scholarship organization into schools, you run risk of it going to private religious schools. And because there are more than 90% in the SSO that are public or private religious schools, the effect as applied is going to end up there. So the state action
Well, I mean,
draws
I understand that
out.
directive that the legislature gave the agency to, administer this right. But as far as the program itself and the qualifications of people who participate in it, there's nothing that mandates that they give aid to religious schools. That is a private choice that they make.
Except on its face, it may be neutral. As applied, it becomes payments to private religious schools because that is really all that's available in the state of Montana. I see that my time is up. I reserve for rebuttal.
Mr. Mercer. Oh, wait a minute. Mr. McDonald, I'm sorry. How much time, Rex? Yes. 40 minutes.
Good morning. My name is Jonathan McDonald. I'm here on behalf of the Montana Quality Education Coalition. May it please the Court. The reason Article 10, Section 6 of the Montana Constitution contains a broad and comprehensive bar on even the indirect funding of private religious education is not bigotry. According to the verbatim transcript of our Constitutional Convention, it was an effort, a command, if you will, to the legislature to keep its efforts and the public money focused on that which we all share, our robust system of a free, quality public education. As Delegate Burkhart prophetically said during the debates, any diversion of funds or effort from the public school system would tend to weaken that system in favor of schools established for private or religious uses. And to that end, I would ask this Court to take a look at the official actions of the state since the 2015 legislature. We know that the state budgeted the $3 million to be used on tax credits that benefit private and predominantly religious education. As the state's budgetary outlook began to worsen, the 2017 legislature was called upon to make some choices. The legislature's obligation is to pass a balanced budget. What the legislature chose to do in 2017 was to continue to fully budget the $3 million necessary to implement this tax credit program. At the same time, it cut tens of millions of dollars from the public schools. In Senate Bill 261, Section 25, $3 million of the tens of millions that was cut from the public school system last time was for money for something called the Data for Achievement payment. It's part of the base payment that forms the school funding formula. This payment exists as a way to pay schools to test and track student scholastic achievement. Now that's important because the legislature defined what it means to have a quality public education in Montana. And that includes at 20-9-309, a system by which student achievement may be tracked by data. So we have a situation where the legislature continues to fully budget the money needed to implement a program that benefits private education while simultaneously cutting funds that go specifically to money that funds part of what is a quality public education in Montana.
So, Counsel,
yes.
What about, and this goes back to the question I asked Mr. White, what if they did away with the $3 million cap and instead just you had the same statute, but you replaced it with a fiscal note, just like you would do with the, what is it, 2326, that allows you to donate and get a tax credit for donations to public or private, including religious universities. So there's no money set aside per se, but there is just a fiscal note that this is what we estimate in the coming biennium is going to be, we're going to have out of these, from these tax credits.
I think the perspective of the public school community, Your Honor, would be that there would still be problems with this program. Whether this is an appropriation is only half the question of what's prohibited by Article 10, Section 6. The other part is whether or not this is an indirect payment. Whether or not the legislature has used its power to pass laws to move
well,
money.
Except for Article 10, Section 6 specifically says direct or indirect appropriation or payment. Okay, I see what you're saying.
Yes.
But so how does, I still don't see how, I'm trying to reconcile how
Sure.
2326 is constitutional and this is not.
And 2326 is the
That's
public.
the 10% tax
Oh,
credit
that's the endowment.
for donations to foundations or endowments for universities,
You know,
which can include, as was in the Department of Revenue's brief, can include religious universities.
whether or not there are problems with the endowment tax credit is a separate question. And there may be, Your Honor. There may be under Article 10, Section 6, which was designed to be among the most stringent in the nation in terms of prohibiting the funding of private religious education. But that's a question based on the unique facts of that case and that deduction, which doesn't include a maximum amount, which doesn't provide a dollar-for-dollar offset. And the reason this is an indirect payment is the legislature has said we can't give money to private religious education. We recognize that. So they're having the public do it, and they give the public a dollar-for-dollar offset against what the public owes the state. For an example, if my wife dislikes the ACLU, but I'm pleased with the work that they did in this case, and she says, no, none of our money, don't give them a donation, I don't want any of our money going to the ACLU. Dan owes me $150, and I say, Dan, don't pay me. Donate that money to the ACLU. I've made an indirect payment to the ACLU. This is the same situation, just writ large. The legislature has said, we can't give money to private religious organizations, however, you can. So we're going to give you a dollar for dollar back when you do it.
Counsel, in regard to the extraordinarily stringent nature of Article 10, Section 6 of the Montana Constitution, as it relates to the federal constitutional establishment and free exercise clauses, you, amicus, and the appellant seem to want to more closely analogize this situation to the Locke scenario, whereas the parents seem to want to analogize it more closely to this Trinity Lutheran scenario. And I guess I'm having a hard time tracking how you are or can clearly distinguish this situation from the Trinity Lutheran situation.
I think that the Trinity Lutheran situation is resolved with footnote 3 of that case, which limits its holding to playground surfacing cases and does not address religious uses of funds. The U.S. Supreme Court was very divided in Trinity. There's a whole host of different perspectives that are offered in that case, and it does not address by its very specific terms, although some justices are there, it does not address the issue of religious uses of the funding, which religious education obviously is.
You only have a couple of minutes left.
Yeah, the difference, Your Honor, is footnote 3 of Trinity. It resolves that question. Thank you, and I'll give the rest of the time for Dan for rebuttal. Thank you.
Mr. Mercer.
Mr. Chief Justice, members of the court, on behalf of the plaintiff/appellees, I'm William Mercer. I'm with my co-counsel Richard Comer. We're going to divide the argument pursuant to the court's order such that I will deal with the appropriations issues. Mr. Comer will deal with the balance of the issues that are at issue in the case. And may it please the court, we ask that this court affirm the district court because the district court was correct when it made a determination that Rule 1 is ultra vires. To reverse, you must find that the appellants prevail on all three issues. They would need to prevail on the question of whether this is an appropriation of public money. They would need to prevail on the fact that that money was going to a school. They would also need to prevail on the argument that this isn't unconstitutional. And we believe they fail on all three, but any one of those is adequate for an affirmance in this case. I want to pick up where Justice Shea has been focused on his questioning of Mr. White because we think that's really a central question here.
Well, let me ask you about that then. I mean, Mr. McDonald argues that the state has an obligation to provide a free, quality public education. And that doesn't apply to secondary schools. That applies to primary schools. So why is any discussion about, and that the purpose of the rule is to support the state's obligation to meet that requirement to provide quality, free public education. So why is the discussion about secondary schools relevant?
Well, the discussion about what was relevant in 72 at the time of the Constitutional Convention is the focus of our argument, which is the department wants the court to believe that in 1972, the founders decided that there couldn't be any sort of support through a tax credit program, and yet we know that there were deductions that were available to taxpayers for contributions to not only religious colleges, but foundations that would support higher K through 12 education in the state of Montana. So the idea that somehow in 2015, when the legislature said we're going to structure a tax credit program, the department comes in and says that is unconstitutional if it's structured the way it is, and yet when we go back to 1972, that's exactly the structure was in place. If a donor gave money to Carroll College or to the Butte Central Foundation in 1975 and said, I want to be able to have this eligible for a deduction, or if within the period of the qualified endowment tax credit said, I want to give money to the Carroll College Foundation or a high school foundation supporting religious education. All of those tax credits were available. They were known in 1972. So this to us is central to the question of what 10.6 means. If it means, it can't mean what the department said, because the founders were fully aware of the fact that tax credits were being utilized to support religious institutions offering educational programs in the state of Montana. So that informs the entire question of whether this is a piece of legislation that exceeds the authority granted to the legislature by the founders under 10.6. So we think it's dispositive. What they knew then and what was being implemented makes this program in 2015 viable.
But counsel, what I'm hearing, or at least what I think I'm hearing from the Department of Revenue, is that the problem is not necessarily some of the structure of it existing in these other programs in 72. It's, as applied, the functional effect of this different than the tax deductions for all universities, that as applied, it's strictly being applied to religious organizations or religious schools. And so how do you address that?
Your Honor, I think what I have understood from the briefing and from Mr. White's argument is that somehow because this is a dollar-for-dollar tax credit, that makes it constitutionally suspect compared to a 40% credit, which is what you have with the qualified endowment tax credit, or for that matter, just the regular standard deduction. Let's leave credits out for a minute and say if I make a $1,000 contribution to Carroll College, that's going to be eligible for a deduction under the Montana Code. The state is trying to say there's something special about the fact that this is a $150 credit where you get $150 back. And we look at the constitutional language in 10.6 and say, if you cannot have any tax credit program that would be designed to benefit religious colleges and schools, then the idea that somehow it's broad-based as opposed to narrow and only, in this case, a dollar-for-dollar tax credit, it's a distinction without a difference. And they're trying to say that the Constitutional Convention founders wouldn't have contemplated this at all, and that just, the fact that it's dollar for dollar doesn't strike us as a relevant consideration. I want to turn to some of the authority that was referenced very briefly. DOR has persisted in arguing that Montana is unique in terms of its language. We've cited the Gaddy case, the case 2017 from the Georgia Supreme Court. Quickly citing there, they say, but our sister state of Florida has an almost identically worded anti-use clause in its constitution that prohibits the taking of public money either directly or indirectly to aid any religious institution. Florida and Georgia's courts have affirmed programs that look very much like this one with constitutional language that is very similar. For this court to go down the road DOR wants to take you would be taking Montana well off the course of what all the other courts that have been looking at these programs have decided, and we think that is not demanded by the Constitution and would certainly create a problem in terms of us being an outlier.
Counsel, can you address in that context what appears to be unique about this piece of legislation, which is a $3 million? Can you put that in the context of how that works and is different from just, for instance, in Zellman and those cases where it was a strict credit?
Your Honor, I believe that the question posed by Justice Shea initially is right, that there is a cap set forth in 1533.11.5a that says if, as these tax returns come in, we, the Department of Revenue, will be monitoring what the balance is. And in fact, if we ever got to a point where we had $3 million that had been claimed, then any other taxpayer that came in and said, I want the $150 tax credit, isn't going to get it because it's a cap. That's what it's designed to do. So
there's no appropriation of that $3 million anywhere. It's just saying we're going to limit and that's how I read the statute.
Well, and I think importantly, in our view, you can go through the briefing and you will find no discussion that you just heard from Mr. McDonald. That was all outside the briefing. So we haven't had a chance to respond to that. But I don't believe it's relevant to the question because we have a cap and we have a program that would have clearly passed muster and was understood by the founders of the Constitution in 1972. So whether it's a cap or whether it's something else is again a distinction without a difference. But we believe that it's simply a cap. I want to also turn to what Judge Sherlock said in a case that we cited, which we think is very significant. We certainly admit that this isn't Supreme Court authority. He cites Nicholson, and he says a number of things that are really central to what we believe is at play in terms of appropriations law and public purpose law. He says, first, the money, whether it is in the form of a tax credit or tax refund, is not set aside for a public purpose. Rather, the money is a tax refund or credit that a taxpayer may or may not claim. In the case of the credit, it is money that was never in the general fund, and in the case of a refund, it would be money that the state is not entitled to keep. He goes on to say, in Montana, it has never been held that an income tax refund to which a taxpayer is entitled is an appropriation requiring an act of the legislature. Section 1530, 26024 provides for income tax refunds, and Section 178101.4 provides that money paid into the state treasury under circumstances such that the state is not legally entitled to retain it may be refunded upon submission of a verified claim. So, in terms of whether this runs afoul of appropriations law or whether it runs afoul of whether this can be a refundable credit, even if we believed that that language was somehow a prohibiting provision in 10.6, this shows that on the mechanics of the way this program works, it's not public money, it isn't something, it is a private donation, it's not public money, and it doesn't trigger the language in 10.6. And again, we believe that the way the state has attempted to construe 10.6 is completely inconsistent with what was known at the time of the Constitutional Convention about donations deductible under Montana tax law. So in summary, we would say there are two district judges that have looked at this law and believed that the position of the plaintiffs was correct. It is noteworthy that the Solicitor General of the state of Montana weighed in at the time this rulemaking was proceeding and said that he believed that it was neither necessary or appropriate. He believed that it called into question the constitutionality that we have raised here. And on any question that the department is entitled to deference based upon its rulemaking authority is severely undercut by the fact that the chief legal officer for the state of Montana looked at this and said, if you do it, we won't defend it, and it isn't appropriate given the legislation. And finally, the U.S. Supreme Court in the Arizona case that was already discussed, and the 10 state appellate courts that have looked at these sorts of scholarship programs and have determined that they would pass muster and not be unconstitutional, given similar language, is central to our position, and we believe further grounds that this court should affirm the district court. With that, I'll yield the podium to my colleague, Mr. Comer.
Mr. Comer.
Good morning, Your Honors. I'd like to make a couple of points initially to clarify some possible misconceptions. First,
would you speak into the mic, please?
Thank you. First, we do not argue that the state has any obligation to fund religious schools or religious education. We argue only that when the state allows tax credits for scholarships awarded to students attending secular private schools, it cannot deny tax credits for scholarships for students attending religious private schools, like the parents in this case. Second, discriminating against families choosing religious private schools in favor of those choosing secular private schools cannot be justified under either the Montana or federal constitutions. Besides not involving public funds at all, the program does not constitute unconstitutional aid to religious schools under Article 10, Section 6. The scholarships generated by the program aid the scholarship recipients and not the schools they happen to choose. The relationship of the schools to the parents is a commercial transaction, not the provision of aid to the schools. The schools exchange their educational services for tuition from the parents. The parents are the intended beneficiaries of the assistance. Montana case law supports both of these propositions. The Nicholson and MFT cases support the conclusion that tax credits are not appropriations of public funds, and the Chambers and Montana State Welfare Board decisions support the conclusion that the scholarships aid the families. The department and its amici have cited no Montana's cases interpreting Article 10, Section 6 that support their reading of this provision. We have cited we have cited the two cases that this court has decided on those propositions. The Chambers case represents a perfect example of an indirect appropriation or payment to aid a religious school. In that case, Deer Lodge County passed a levy which would fund 8 school teachers to be employed by the public school district, but who would teach secular classes at the Anaconda Central School, a Catholic school. This is a clear example of indirect aid to that Catholic school, and this court prohibited that aid. It did it in 1970 on the brink of the 72 Constitutional Convention. And to the extent that the language of that provision was not amended in any way relevant to their holding, that holding carries over onto the new language. That's an indirect appropriation to a religious school. A year later, this court decided the Montana State Welfare Board case in 1971. In that case, the Montana State Welfare Board relied on Article 10, Section 6 to argue that state funds could be denied to indigent expectant mothers, funds that were used for housing, foster care, and medical services could be denied if they selected a religious provider for adoptive services. In other words, the mothers were being supported till they gave birth, and they were then going to give up their children for adoption. The Montana State Welfare Board said, if you have to do that with us, you cannot do it with these 3 private providers because they are religious institutions. One was Catholic Charities, the other was the named defendant, Lutheran Social Services. The mothers wanted to give their children up for adoption by them, but they would have had to have sacrificed any aid from the Montana State Welfare Board that was provided if they were prepared to give up their children to the board for adoption. This court said that that was not aid to the religious providers and distinguished the Chambers case. So here we have 2 decisions that carry over into the interpretation of Article 10, Section 6, both of which support the conclusion that indirect aid does have meaning, but it has to be indirectly benefiting religious institutions as institutions. And we have another decision that distinguishes that on the basis that the aid is for the benefit of the mothers. In this case, it's also for the benefit of the mothers. They would like to compete for scholarships that are generated by the tax credits that the state gives out to private taxpayers to encourage them to make private donations.
So, counsel, let me just, I understand the purpose of the legislation is set forth in the statute that it's a matter of choice, but it's interesting that the cases, and I'm thinking particularly of Zellman, the Cleveland School District was under a federal supervision order. And so the opinion is written in the context of the legislature trying to provide an alternative way of dealing with this inadequate public school system. We don't have that. There's no allegation here that Montana schools are inadequate. And so the purpose is purely one of choice. And I think, I guess, could you address that in terms of where this legislation is in the context of those other precedents?
I think there's two things to point out. The Cleveland case is not the only direct scholarship case in the United States or program in the United States. There are many of them. It just happened to be the one that we lost at the Court of Appeals and that the Supreme Court granted cert on and reversed. And they focused on the facts of the case, the structure of the program. And I don't think that it was vital to their decision that the public schools in Cleveland were so bad, because Ohio now has a statewide scholarship program that goes far beyond the original Cleveland program, and there are similar programs like that elsewhere in the United States. However, in that case, they weren't even dealing with tax credit. That came later when the Supreme Court, as you noted, discussed the Arizona Christian School Tuitioning Organization versus Wynn case. And there they held that tax credits that generate scholarships aren't using public funds at all. So even were it necessary for a direct voucher case that the public schools be failing, which I don't think it was critical, we are dealing with a easier case, if you would, a case where the funds are not public funds. Obviously, like 48 other states, Montana has a balanced budget requirement. There's one that doesn't, but that's Vermont. We don't need to talk about them. When you have a balanced budget, you have to consider revenues and expenditures. And all of these tax benefits, all of them, including the 40% tax credit for donations to qualified college endowments, all of them reduce revenues. And so, of course, you have to pay attention to that in the budget. This being a brand new one, we don't really have any experiential basis for understanding how many people might use it. And so, I think in an exercise of sound judgment, the legislature said, we'll cap that at $3 million because we don't know. Maybe it would take too much revenue away from the state. But that's the amount of money, $3 million, is minuscule in comparison to the tax benefits the effect of the tax benefits of these deductions for donations directly to churches, directly to religious schools, directly to families who donate to the other scholarship fund. There are two in Montana. The one that has pre-existed this program and that today awards nearly 750 scholarships to Montana students. That's the ACE Scholarship Fund, and it's described and discussed in the amicus brief that they filed in this case. This isn't something brand new. What is new about this program is that it incentivizes small private donations of up to $150 to another sort of scholarship fund. So far, there's only one, but this program was modeled on Arizona. Arizona has 50 scholarship granting organizations, one of which was the subject, the defendant, or an intervener actually, in that Axto case, the Arizona Christian Commissioning Organization. So this isn't something new. And I believe that it is something that is clearly authorized by the Constitution of Montana and clearly authorized by the education article. As in other states, 99.99% of education spending is and will always be on the public schools. But it doesn't have to be. The Constitution, voted on by the people, does not limit funding to the public schools alone, however much MQEC wished it did, but it doesn't. The language of the Constitution I'm referring to is Article 10, Section 1. Two-part subparts. Subpart 1.1 says it is the goal of the people to establish a system of education which will develop the full educational potential of each person. Equality of educational opportunity is guaranteed to each person in the state. And then subsection 3 says, the legislature shall establish a basic system of free, quality, public elementary and secondary schools. The legislature may provide other educational institutions, public libraries, and educational programs as it deems desirable. That language is about as clear a delegation to the legislature as you can find in any state constitution to go beyond establishing and funding public schools. Moreover, this provision, the rule that the Department of Revenue has enacted clearly violates that language in the first subsection about equality of educational opportunity is guaranteed to each person in the state. Our parents live in Kalispell. They have 5 alternatives for educating their elementary school children. They can send their kids to the public schools for free, or they can choose one of 4 private educational schools. 3 of them are religious. Stillwater Christian, where our clients send their children. And there's a Catholic school and a Lutheran school. There is also Kalispell Montessori School, serving grades K through 8, which is a private, secular school. Parents like ours, if they choose to send their children to the Kalispell Montessori School, can obtain, under Rule 1, tax credit generated scholarships, which are all funded with private money. But if they choose the Catholic school or the Lutheran school, or Stillwater Christian School. They can't. That's as clear an example of discrimination as you can find. And it is a violation, not just of Article 10, Section 1, Subsection 1, equal opportunity, but it's a violation of the Montana Equal Protection Clause. It is a violation of the Montana Establishment Clause, and it is a violation of the Montana Free Exercise of Religion Clause. To say nothing of the fact, it violates the exact same parallel provisions in the federal Constitution, namely the federal religion clauses and the federal equal protection clauses. There is no question in that this program, without Rule 1, is constitutional under the federal Establishment Clause. That has been established in Zellman versus Simmons-Harris. It has been established in WIN, or Arizona Christian School Tuitioning Organization versus WIN. The Equal Protection Clause renders religion a suspect classification. If you go back to the Caroline Products case of 1938 in footnote 4, which is the origin of strict scrutiny of protected classifications, they don't just list race, color, and national origin. Religion is in there too.
I think what the DOR's argument, counsel, is that it's clear that the line between the Establishment Clause and the Free Exercise Clause has been somewhat set out clearly in Zellman and those cases. I think the question is whether Section 6, which is an Establishment Clause provision, whether the Montana Constitution can continue to exist without conflicting the Free Exercise Clause of the First Amendment.
Yes, and I think that question is answered first in Locke v. Davey, which is far narrower than they have characterized it, because unlike this provision, the Supreme Court in Locke v. Davey emphasized how much religion still benefited from the scholarship program there. People could attend religious schools with this scholarship. They could study religion at those schools.
Your time has expired.
Thank you, Your Honor.
Rebuttal.
Mr. White, I want to follow up right away with something that Mr. Comer was saying here. I agree with you, at least as far as this goes, that this is clearly an indirect appropriation or payment. But the question in my mind is to who? And I think that's where this argument that they're making is very strong based upon this Montana State Welfare Board case and the cases that are also cited from other states, largely at pages 23 to 25 of their brief, where the thrust of those cases in the case of the Montana case is that these programs are aiding individuals, not religious programs that they are accessing. And your response to that in your reply essentially is, well, Montana's constitutional provision is much more stringent. And I don't see how that it is much more stringent than, say, in Georgia or these other places. Can you elaborate on that?
Justice Sandifer, there's a couple of points I can make on that. First of all, going to the cases that have been cited, especially, excuse my voice, the Montana Welfare versus Lutheran Social Services case is unique in that it was federal funds and not state funds, so that's one point. And secondly, that went more to a question of the fact that the Lutheran Social Services was affiliated with the Lutheran Church and goes more to a Trinity Lutheran type situation where it's about who they are not where the money was going. And in that case, the money was neutral and going to the mothers for purposes of adoption and that kind of thing.
Well, let me stop you there. I don't dispute that, but I think what the thrust of these cases and the point that they're trying to make with them is that these primarily benefit and aid these parents and these students so they can go out and access this other educational option. But this, so the only way that in my mind logically that you could say this is an indirect aid in the terms of our constitutional provision to religious schools, it's indirect because it's an indirect payment by the state to parents, and then by extension, by your logic, to these schools. It seems to me that's too attenuated to invoke this aid prohibition in our Constitution.
Justice Sandifer, let's be clear on how the mechanics work. It goes from the public funds to a scholarship organization. It bypasses the parents and the children and goes directly to the schools.
Well, I have college-age kids too, and that's how it goes. People have learned you don't put the money in the hands of the kids, or so I don't find that to be a distinguishing problem.
The real distinction, Your Honor, is in the intent by the delegates of the Constitution. When they talked about what to do with the language, there was a movement, there was a motion to take the indirect language out, because some wanted to be able to apply the student benefit theory that is allowed at the federal level through the U.S. Supreme Court. They talked about it at length, and justices like Justice Blaylock said, without indirect in place, it's easy to give money to a third party to give to religious education. For that reason, the majority said we want to keep indirect in. So that is a rejection of this student benefit theory that we're talking about. That's how strict our particular provision is, and why it's more strict than cases like like Arizona in Wynn and Zellman and all of those. It's just the delegates intended to take it to another level, frankly.
Counsel, what if, and I just want to get back to kind of following up on what Mr. McDonald said in terms of how the sausage gets made here. And I appreciate that this was decided on summary judgment, and I think procedurally DOR had requested some discovery before that. But
that's true.
And so if this isn't in the record, then we'll live with that. But my question is, Mr. McDonald alluded to the fact that essentially when they're crafting House Bill 2, or then when we had the special session and they're looking for money, that they essentially, there was this $3 million that was set aside. So in other words, if there was an estimated pie of $100 million, they said, we're really only going to deal with $97 million to fund public schools and what have you, because $3 million can't be touched. I guess you're with the department. I mean, is that in terms of how it actually happened, or because I'm looking at the statute and I'm seeing this again as like a cap. So I'm wondering if this was, it becomes, I guess in my mind, more of an appropriation if you're talking about we're going to set it aside and we're going to pull it out of the general fund and say this is part of our budgeting process.
Justice Shea, while I don't pretend to be a true expert in the budgetary process, other than I appear frequently in front of the legislature on tax issues, the way that they treated the $3 million was distinct from how they do it for any of the other tax credits or deductions. Thank you.
This concludes the oral argument on this matter. The court will now take the issue under advisement, and we will issue an opinion in due course. Some of you are going to stick around. A few of us will come back for discussion with some of the students that are here, but for now, we're adjourned.